Hello, everybody, and I want to welcome you to today's ILTA webinar, GDPR for the Financial Professional. I'm Nicole, and I'll be serving as your moderator today. Our speakers today are Andre Zielinski with Redleg and Gabriel Grums with StealthBits. I want to thank Redleg for sponsoring today's webinar. Today's presentation will run about 45 to 60 minutes, and we ask that you submit any questions you have into the Q&A box, and if they are not addressed during the presentation, they will be addressed at the end. Please know that we are recording today's webinar and we'll post a link to our website under recording shortly after today's presentation. Also, at the end of the presentation, we ask that you take a few moments to complete the evaluation polling you will see appear on your screen. I will now turn the webinar over to Andre.
Yes, good morning, good afternoon, good evening, wherever in the world you are located. Welcome to this webinar. As Nicole mentioned, there will be two presenters. There will be myself, and I'm advisory practice manager at Redleg, and Gabriel. Gabriel, you want to introduce yourself?
Good day, I'm Gabriel Grums. I'm the Vice President of Product Strategy at StealthBits.
Thank you everyone again for attending, and we'll jump right into the presentation. So everyone is hearing a lot about GDPR lately, so I think this presentation is timely. We will try to share some knowledge that we have gained as a part of our daily work with you and give you some advice. The topics that we will be covering are listed on screen, so we will go from the what we need to protect to brief history of European privacy regulations, how to build your GDPR program, and we will bring you up to speed with the latest development in this field. And there will be questions and answers for sure. As usual, a disclaimer. I won't read it. Please notice that this is not a legal advice. And with that, let's talk about what we usually protect. So if you are dealing with security or privacy, usually the main goal of those two disciplines is to protect sensitive data. Whatever we try to do to protect our companies, firms, enterprises, at the end, what we are doing is we are protecting the data. Here are some quotes from the experts which help to understand how we need to address this question. So first of all, we need to understand where the sensitive data resides, because when you're trying to protect your crown jewels, unless you know where those crown jewels are, it is really difficult to put effective controls in place. And here is another good quote, that navigation is possible without a map. Not knowing one's data prevents a company from transcribing its data, and this makes security hard, governance harder, and privacy protection impossible. So I think this summarizes pretty well the approach. So when we are dealing with GDPR, what we need to do is we need to understand what we are protecting and how we are protecting. Brief history of European privacy regulations. GDPR is not the first regulation that EU has introduced. The first regulation was actually introduced in 1981. And the purpose of that convention was to protect individuals against abuses which may accompany the collection and processing of personal data. So it was called Automatic Processing of Personal Data, ETS 108. So again, the date was January 1981, so some time ago. Now this was improved and expanded in 1995. With the Data Protection Directive, Directive 95/46/EC, and the purpose of this directive was to provide transparency, legitimate purpose, and proportionality when the personal data is collected and processed. GDPR came into play, was developed pretty much for the last couple of years, and becomes effective on May 25th. May 25th this year. GDPR stands for European General Data Protection Regulation, and it is considered pretty much by everyone as the most important change in data privacy. It will affect not only EU, but pretty much will affect everyone in the world. One interesting thing, and we talk frequently to different companies, to different law firms, about how GDPR is enforced. And one of the questions that we get all the time is, what is the way for us to get certified? So one disclaimer immediately is that there is no certification. One of the main features of GDPR, it is a self-monitor regulation. So if somebody is offering you to provide you with a certificate that says that your firm or company is GDPR compliant, don't fall for that. There is no certificate like that exists right now. It doesn't preclude that something like that will be introduced in the future, but for now there is no official certification that states that your firm is compliant with GDPR. So it is self-monitored. It's a responsibility of each entity to be GDPR compliant, and it's a responsibility of each entity to report data breaches. But again, there is no certificate or paper that will confirm that you have achieved the state of GDPR compliance. Readiness, as we saw on the last slide, and pretty much everyone knows by now that it comes into force on May 25th. Lots of companies are in a different state of readiness. So this is an interesting survey that was conducted in US, UK, and Germany and Australia. Pretty much covers the main areas of the world that will need to meet GDPR requirements. And you can see the numbers here, right? So it looks like technology and telecoms are leading in readiness. It lists their self-assessment. Now, healthcare is the least likely, 17%, and legal, 21%, we have highlighted, is pretty much on the level of retail and marketing. So they're somewhere in the middle between technology and healthcare. Country specifics. One of the features of GDPR compared to previous regulations is the fact that GDPR does not need to be approved as a legal law or legal act within specific countries. So GDPR pretty much governs all EU countries. Previously, with the previous regulations, you needed to have a corresponding local law that would implement requirements in a specific country. Now, with GDPR, you didn't need that. What is interesting, and those of you who have ever worked with German privacy requirements would know that they're extremely strict based on the historical events that happened in that country. So Germany has went ahead and actually has enforced local regulation besides GDPR regulation, and it was enforced on July 5th, 2017. I won't try to pronounce the name, but this was passed as a German Data Protection Amendment Act, and pretty much requires, puts together the same requirements as the ones that are specified by GDPR. Situation with UK is also interesting. Everyone knows that UK is leaving EU as a part of Brexit, but UK has confirmed that they will comply with GDPR requirements. This was announced, as you can see, on by UK government. Interesting fact, also interesting information. There are lots of conversations right now on how GDPR will be enforced once May 25th is on the calendar, right? Do you have to be compliant right away? Will you face penalties immediately? So here's an interesting quote that was published a couple days ago on BBC, UK news site. And those are the quotes from Elizabeth Denham, who is UK Information Commissioner. So some quotes are interesting. So she says that the first things they're going to look at is whether the certain steps were taken. So whether the companies and firms are trying to be compliant, whether there is a commitment to GDPR. And the third bullet point I think is extremely important, is that they're not going to be looking at perfection. They're going to be looking for commitment. So because as you saw the numbers of how companies are feeling of being prepared to regulation becoming active, right? There is an understanding that not everyone will be, and majority of the companies will not be ready for GDPR, will not be fully compliant. The idea is that you need to do as much as possible to be compliant. And perfection is not the goal. You need to start the process. You need to be able to show the progress. key elements. What defines GDPR? So the key elements of GDPR are enhanced personal privacy rights, increased responsibility for protecting personal data, mandatory notification, reporting about the data breach, and significant penalties for non-compliance. Those are 4 elements. GDPR goes through lots of rights that any individual or data subject will have under GDPR, and those rights are listed here. One of the most important ones are the right to erasure, the rights to restrict processing, the rights of access, and there are some additional rights on this page. The right to data portability, which becomes important when you switch services. There is also a movement towards specific banking regulation in EU, which would allow you to switch your, for example, banking providers with ease, and this is where the right fits in perfectly, that you can initiate the data transfer between service providers without getting in a situation when it becomes difficult or infeasible for you to do that. Consent. This is an interesting topic that is being discussed, and there was a specific publication that was released in UK. How to deal with consent. The reason why it is so important, it is that the fact that if you are in a position of power, you can pretty much force consent from the people or employees who depend on you. This is extremely important when you are dealing with the privacy data of your employees, because when you are building your GDPR program, one of the things that you will be looking at, and this will be covered a little bit later in this presentation, how you deal with the data of your employees and whether that consent that they give you for handling the data is sufficient and considered to be appropriate for your internal operations. So here is an example of how consent will apply. So a company asks employees to consent to monitoring at work, but again, employees are dependent on the company for their salary, for work. So if they agree to it, it may be not because they're willing to agree, but because in the position they're in. Interesting consideration when you look at GDPR is data controller versus data processor. So when you read through the regulation, there are always 2 possible states that your firm or company or entity can be in. You can be a data controller and data processor. One of the best ways to determine whether you're a data controller or data processor is to think about this way. If a data subject asks you to remove his or her data from the systems, will it affect your operations? If it does affect your operations, you're pretty much a data controller. If it doesn't, you're a data processor. So data processor in this case usually would be a company that assists you with the processing of data subjects information. Can be something like shared storage, third-party servers, analytics. So this is something that you need to be aware when you're dealing with GDPR. You can be in one of the states. You can be either data controller or data processor, or you can both. There are cases when your, again, entity can be both data controller and data processor. GDPR has introduced an interesting position, which is called data protection officer. Data protection officer, not to be confused with the data privacy officer, is a key figure when you deal with GDPR. Initially, this position was supposed to be mandatory, but it has changed in the process of law development. It is not mandatory, but it is a desired position to have if you're serious about your program. And if you remember when we looked at that quote from UK Information Commission about the fact that they will be looking at how you're approaching and how serious you are trying to achieve GDPR compliance, this is one of the facts that to keep in mind. Also, it was interesting that Bavarian Data Protection Agency in Germany actually did a polling of 100 companies in Bavaria to judge their readiness for GDPR. And one of the questions in that questionnaire was actually, do you have DPO assigned? And the second question right after that was, if not, why? So pretty much this position, even though not mandatory, is taken very seriously. This is a person who will be in charge of GDPR compliance program implementation. Doesn't need to be an employee of the company or firm, can be somebody representing a third party. And another important thing is that this person is supposed to operate independently of organization. What it means is that his or her judgment will not be influenced by business objectives organization, and this person actually, the main goal of this person is actually to achieve compliance and to make sure that compliance is achieved the right way. Position is so important that there is a special document released by EU, which is called Guidelines on Data Protection Officers. So it's an interesting one to read. Another important point to keep in mind is that DPO is not personally responsible in case of non-compliance. So if the company or a firm or entity is not compliant, DPO doesn't bear any legal responsibility for that. There is another position that we will discuss a little bit here, is national representative. If a company, a firm, or again, entity is located outside of EU and is not, as they say, well represented in EU, but still deals with the privacy data of EU data subjects, the company needs to be compliant with GDPR regulation. In this case, if a breach happens, and to interact with regulatory authorities in European countries, a company needs to, or a firm needs to assign somebody who acts as a national representative. This position is separate from DPO. It has to be somebody who resides in EU. As compared, DPO can be a person either in EU or outside of EU. And national representative is the one, again, who reports any data breaches. And that person can be liable in case of non-compliance with GDPR. So this is something to keep in mind. It's separate from data protection officer. When we look at DPO, usually there are some similarities between DPO and CISO. CISO, as you know, is Chief Information Security Officer versus Privacy Officer. So CISO, to put it in a short, explain it in a short way, CISO is more technical, less focused on privacy, more focused on computer operations and security requirements and protecting the company as entity that needs to protect its crown jewels. DPO is somewhere in the middle between CISO and privacy officer. So DPO needs to have a strong understanding of technology, just because when GDPR program is implemented and actions are taken to make an entity compliant, you need to look, and we'll cover it a little bit later, you need to look at specific controls, you need to look where the data is located, you need to understand how the data is accessed. So being technical is one of the requirements for DPO. Now, privacy officer usually is a person who has some legal background only and may not understand technical side of the things as well as it is required for this position. There is ongoing discussion whether a lawyer or counsel is a perfect fit for DPO. Again, if a person has great legal expertise and at the same time has good understanding of technology, that may be a perfect fit of organization. So the person that combines, again, legal knowledge with technical knowledge, those people are quite rare, but that's a perfect candidate for a DPO position. GDPR breach reporting, something that is mandated by GDPR is that breaches should be reported within 72 hours. One thing to point out is that 72 hours are becoming standard for breach reporting. As an example, we can refer to last year in the state of New York in the United States. special regulation was adopted for financial services companies that conduct business in New York. Usually it's referred as NYDFS. And that regulation also specifies that if a company that provides financial services in New York has a data breach, that data breach needs to be reported within 72 hours. So this is another example. So 72 hours are becoming prevailing time period that you need to report breaches to regulatory authorities. Penalties. This is an interesting part, and you will see later about some information about Facebook and other companies. So those are non-negotiable. And the interesting word here to notice is the word greater. So every time you talk about the penalties, you have two numbers, right? One is the number in absolute value in millions of euros, and another number is a percentage of your, you have here global annual revenue, or the way it would be referenced in the United States, turnover. So those numbers are quite significant. And as you can see, again, this is something that is either or, but the greater number is applied. And the maximum penalty is 20 million euros or 4% of the global annual turnover. So there was a conversation about Facebook in case of the data breaches, which were a result of activities of Cambridge Analytica, if my memory doesn't betray me. The penalties for Facebook, if GDPR was active at that moment, could have reached up to $1.4 billion. So significant, and something to keep in mind when weighing your decisions whether to proceed with GDPR program and how much to invest into the program. And I'll pass presenter role to Gabriel. He will cover the next slides.
Excellent. Thank you very much. A lot of really good information presented there. Pardon me. And GDPR has a number of requirements. We're gonna double click into a few of them in a little bit more detail. Certainly the ones that we believe are the most pertinent for ensuring your overall compliance and your continuing compliance. But just from a top-down look at what some of those requirements are, starting at the top and kind of working our way down. It mandates that you have to keep records of all processing of personal information. And so what that means is, as you take in information from EU citizens, it is important that you have documented how that information is being processed, how it's being handled, where it entered the organization, where the data flows throughout. In fact, there are requirements for data flow mapping capabilities to understand throughout the environment internally where that information is flowing. So for example, let's say you have a website that takes in information as part of a sign-up process. Let's say maybe you're an educational institution, even based here in the U.S., and you have EU citizens that apply to your institution. When that information enters through that web application to where it's stored within the database, to where it's handed off to individuals who are reviewing it, all the way to the point whereby you either archive and or delete that information. You have to be able to account for all of the processing of that information. And if a lot of times folks think about the processing as only the final result, that is, once the information is in the hands of whoever the data processor is, if I break down internal terms from data owner to data handler and so forth, data operators. But the processing in GDPR covers the entirety of all the processing from the time that information is received until it is no longer needed by the organization. And then you have to have safeguards for cross-border transfer. So that requirement is a holdover from some of the past regulations that the EU had with regards to overall citizen data handling, whether we're looking at the original Data Protection Acts, or we're looking at or Privacy Shield and so on, there needs to be some safeguard in place for how data is transferred across borders. Maintain appropriate data security. So it's a little broad, but when you go into the details of the regulation itself, there are some specifics with regards to that. It calls for things such as ensuring that there are least access privilege models in place. So when we talk about maintaining quote unquote appropriate data security, we want to ensure that data isn't exposed and or available to those that don't have a need to be exposed to it. And we'll touch on that in a little bit later as well too. Collect personal data lawfully and fairly, and where relevant, get appropriate consent, provide notification of personal data activities. We touched on consent just a little bit earlier, and just to recap what that means is basically you have to have consent from the person that you're collecting this data from with regards to collecting it. You have to notify them as to what your intent for collecting that data is and what it will be used for. So there isn't under GDPR, there is not an implicit consent as there may be in other countries or in the past, whereby once someone hands that data over to you, that it is implied that that they've consented to your processing that information. Under GDPR, you have to actually provide notification of that consent, as well as what will happen to that data. The same is then true for individuals under the age of 16. So this is again a holdover from other regulations that we've seen both in the US and in the EU with regards to things like FERPA and so forth. Minors are not allowed to give consent, and that extends to GDPR as well too. So whether that is someone under the age of 16 entering their information through again, we'll take a web application, for instance, whether they're part of a marketing campaign and so forth. They cannot give consent, and so that consent must be passed down from their parent. Consult with regulators before certain processing activities. This one specifically is with regards to what happens after you no longer business need to the data as well too. So there are some exemptions for how long and what types of data you can hold on to, but you should consult with regulators. As we mentioned before, this does not equate to legal advice, but under certain circumstances, if you have a lawful reason or a research reason for maintaining access to and or processing that data, there are certain activities around there that you may be exempt from, but you certainly need to still consult with those regulators before you continue that processing. And then provide appropriate data protection training to personnel that has access. So the general idea there is, from a privacy by design perspective, we're not just looking at how we control and how we protect that data, but it's equally important that all individuals that are involved in the processing of that data are aware of how their handling of that data affects the overall privacy of the data that they're working with. Next slide, please. So to continue in that path, conduct data protection impact assessments on new processing activities. So Andre mentioned earlier that GDPR is a largely self-governing regulation, and this is one of the more important self-governing activities that you will have to perform, which is the data protection impact assessment. PIA, as you'll sometimes hear folks call it for short. You have to basically perform an internal review, but more or less a self-audit of those processing activities to ensure that you are maintaining a state of compliance at all times. We've touched on impact of data privacy by design. I'll get into that in quite a bit more detail in a few slides. Suffice to say at this point, though, that what is important here is that privacy by design takes the concept of data protection further than just ensuring that you are compliant with regulation, but more importantly, ensuring that all of your activities as an organization take into account the privacy of the data subjects whose information you will be handling. Appointment of a data protection officer, we touched on that quite a bit. One of the things that I wanted to expound upon a little bit more there is that role can certainly be filled by someone that may already have similar duties today within the organization. It could be a chief information security officer or something of that sort. Things that GDPR do not explicitly say where in the reporting structure internally that has to exist. But as mentioned, it's an extremely important role and will be scrutinized, so you want to give that careful consideration. Being able to demonstrate compliance on demand, this goes back to that state of readiness and why things like the PIA are so important. You can and will be asked at any given point to prove that state of compliance. And I think in today's atmosphere, that has become even more important. And I suspect that we're going to see a lot of that out of the gate. And in notifying data protection agencies and affected individuals of breaches in certain circumstances. We cover that as well. You have that 72-hour period whereby you will have to perform that notification. The reason why that became so important has quite a bit to do with the length of time that we've seen organizations take to alert folks that their information may have been exposed, leaving those individuals kind of open to maybe any further damages or impact by especially malicious taking of that data. All right, let's keep moving.
Perfect. So thank you, Gabriel. So how do you implement GDPR program? As pretty much with any large undertaking, right, you need to plan it and have certain phases that you go through while you're trying to achieve this result. So as Gabriel has mentioned, the first phase usually that you go through is called Initial Privacy Impact Assessment, PIA. So what you do is, and usually this is done through the interviews. So you would have interviews conducted with people who manage your company or firm, with your IT personnel, to figure out how the data flows are happening within the firm. If you talk about a legal entity, right? What data you collect, where do you store it, how you process it. Extremely important is information on how you share this data with the third parties, because pretty much there is no business these days that doesn't use certain services that are outsourced. In some scenarios that will be something like cloud services provider. In other cases that will be some data entry company that may be located in abroad, not specifically in the United States. So again, you need to understand, and this is again goes back to the fact that we discussed in the beginning of this presentation, so that you need to understand where the data is and how you deal with the data. Extremely important when you're establishing the program. Another fact is how you minimize the data. Another area that you need to investigate, how you minimize the data. You don't want to collect and store more data than is actually needed for what you're planning to do. So data minimization is extremely important as a part of this initial assessment. Availability, your ability to comply with right to erasure, right to be forgotten. One of the examples that we always give is that pretty much everyone runs data backups right now, right? So for disaster recovery purposes, it is extremely important to keep backups of your systems. And usually standard operating procedure would be to keep those tapes offsite, and you do some tape rotation, and there would be some backups that stay in that storage for quite some time. So imagine that you're backing up a SQL database that contains privacy data, information for a subject of GDPR compliance, right? And that person asks you to erase the data. How do you do that? How do you erase the data from those backups? Because unless you do it, you are not compliant, because you haven't fulfilled the request of that person to have the data erased. So this presents a significant challenge to current ways of handling data within enterprise. Usually as a result of this first phase, you would have a gap assessment report, which will look at shortcomings, something that you need to rectify on your way to GDPR compliance. And as a second part of this phase, you will have high-level implementation plan. So that will be the plan that you will follow when you're trying to achieve compliance. Second phase is the one if the first phase was mostly based, and is usually mostly based on the interviews, and we all know that usually there is a gap in perception of how things are done and actually how things are done. So people, and this is not with malicious intent, but usually people have a certain opinion or certain understanding of how the data is handled, where the data resides, and what entities do with this data. And in reality, there can be a quite significant gap between that understanding or how people imagine things are done and what happens in reality. You need to actually conduct an assessment and conduct discovery to make sure that whatever was discussed and assumed in the phase one of the project is actually what you have. And I'll pass it over back to Gabriel.
Excellent, thank you. So yeah, let's dive in a little bit more and talk about privacy by design. So what it does is it promotes the idea that privacy cannot be assured solely by compliance, as I said before, right? Just solely by compliance with regulatory frameworks, this one in particular. Rather, privacy assurance must become part of an organization's default mode of operation. And that concept covers the totality of data handling, from collection all the way to archival and removal to those data resources, including and certainly not limited to data that's contained on network file shares. They may be SharePoint sites, cloud storage repositories, wherever that data is going to exist. And that covers both structured and structured, and both unstructured and structured environments, such as databases and so forth. So there is no limits to where that privacy by design is going to be implicated across the entire data lifecycle handling, if you would. And furthermore, that privacy by design also requires that we take into account how data is being accessed and how that access is being provisioned to those resources. And again, that gets into being able to implement a security model that's going to limit access only to the right people and the appropriate levels of permissions to those right people, and making sure that that's reliable and maintainable as well too. So some organizations certainly will have to, if they haven't already, go through a bit of access restructuring once all of that data has been identified in those sources, moving from left to right on this here, where we have all of those collection areas, and then understanding who has access to them, how they have access to them, how we can provision and deprovision access based on the needs throughout the different parts of that processing, and restructuring that as necessary to get it down to a least privilege model, and then maintaining that over time so that you always have this continuous certification of not just being able to prove who has access to that data, but how they're actually using the access to that data. Next slide, please. And that flows right into the right to be forgotten, as we just covered. So now let's look at this from an implementation standpoint, from actually operationalizing this. So again, we have all of the collection of the data. We have who has access to all of that data. And as I mentioned before, if we're doing this correctly, we will have mapped those data flows to understand where throughout the environment that data has been processed, so that we can ensure that it is removed from the environment when we need to fulfill this request. And so organizations will need to understand exactly where data subjects' personal information resides across all of those environments, again, in both structured and unstructured repositories across the entire company's network. And identification and cleanup of stale data that is no longer useful and no longer needed is probably going to be one of the most important ways that you can drastically reduce the scope of your obligations under GDPR. We have had a relatively poor IT habit of keeping data around for a long time. Ever since storage has gotten cheaper and the cloud has become more ubiquitous, we tend to hold on to things, especially from a business perspective, because we believe that at some point it may be useful to us, or we believe we may have some legal obligation to hold on to those things as well too. The truth is that just extends the scope of the obligations under GDPR, and eliminating stale and no longer useful data is probably one of the most significant ways that you're going to be able to reduce that obligation. All right, we can go ahead and move on.
Okay. So one of the facts that I wanted to mention agreeing with what Gabriel has said, is what you need to keep in mind is that lots of firms and companies have ERP systems implemented, and those ERP systems, they collect the data as usual, right? And the data usually resides in databases. Most likely this will be a Microsoft SQL database. So one of the things that you should be looking at when you're deciding which tools to use for data discovery, for access monitoring and control, is actually whether your tools are able to handle structured data. Because some tools, when you start looking at those, they can support only unstructured data. Abilities to support both structured and unstructured data from the data discovery point of view is extremely important, again, because there is tons of data sitting in those SQL databases. So once we did that and we went through phases 1 and 2, here is the third phase. Pretty much this is where you're operationalizing the program, right? You are interpreting and applying those data protection rules, and you are maintaining your compliance program. One thing that we always say about security, right, is security is not a state in a moment of time. So you cannot be secure today. You have to be secure and keep being secure for all foreseeable future. Same works for compliance, right? Once you achieve the certain level of compliance, you just don't relax and consider everything is done. What you need to do is to maintain your focus and make sure that your firm, your company, your entity, again, operates according to requirements, and at no time you are backing off of what has been already accomplished and those processes that were put in place. So achieving compliance, making sure that the data is in a good state, you're able to meet those requirements, you went through your audits, assessments, is good. But the most difficult part is probably the one that comes after you reach this certain point in your travel, in your journey. You need to sustain this program for a foreseeable future, because we don't expect this to go away. And this requires, as always, focus from the people who are personally responsible for making sure that this works, and continuous support from the management. During RSA conference that took place, I think, last week in San Francisco, there was, I believe, whole day session dedicated to GDPR. And one of the presentations was done by IBM, and they will be publishing a report in May. But here are key numbers that they produced for that presentation. And again, just a comment on most of those slides. If we quote any information, you will see links at the bottom of the slide. So if you want to read more or gain better understanding, you would be able to follow those links. Something to do on your own. We'll give you additional information. Same here, you'll see the link to the video where this information was presented. So as you can see, based on that survey, again, results will be published by IBM in May. Here are 3 priorities that entities face with GDPR compliance. Complying with the data principles, 18% of respondents. Performing data discovery and ensuring data accuracy. Again, we are talking and we are returning all the time to this data discovery and making sure that the data is accurate. You see, it's priority number 2. At the same percentage point, right? Maybe there was 18.3 and the first one was 18.1, but anyway, you see it as item number 2. And the third one is getting consent from the data subject. So this is also considered one of the top 3. If we move down and look at the top 3 struggles, and you can see that performing data discovery and ensuring data accuracy jumps to the first place. So the importance of this is elevated to the first item on the list. And again, it is extremely difficult to judge correctly how the data is stored and processed based on the information that people possess. You need to conduct specific assessment using specific tools to understand where the data resides and how it's accessible. And to Gabriel's point about tendency for IT personnel to hoard the data, it is a common occurrence when we do audits at the enterprises. Usually you find servers that were supposed to be decommissioned a long time ago, but there is some data sitting there and nobody wants to shut them down because we are not sure whether we will need to retrieve the data, and there are servers sitting in the closet. Access rights to those servers are not kept current, and who knows who has access to that data. So again, you need to do it as tightly and as focused as possible. The second is complying with data processing principles, and the third one, as you can see here, again, we have emphasized the role of DPO, though not mandatory, extremely important, and you can see here it shows up as the item number 3. This presentation is geared towards finance department, finance professionals. So how does GDPR affect specifically people who work in finance? One of the conclusions that we want to convey is that you don't address GDPR department by department. So it's not the sole responsibility of finance departments to be GDPR compliant. The whole organization has to be GDPR compliant. So you should be assisted with, and you should work together with other parts of your organization. Responsibilities that chime with GDPR requirements, archiving, right? So as a finance department, you keep archives of your invoices. Those invoices can contain data that may be subject of GDPR. So archiving, data access. You deal with the customers or suppliers. They may have supplied their personal information. One keep in mind is when you talk about personal data, some of the things would not be obvious. For example, if you talk about computer networking, your IP address and your MAC address may be considered your personal data. So don't take personal data as something that is just obvious. There are different elements of the personal data that come into equation when you deal with GDPR. Record keeping. Gabriel, did you want to add something?
I did. I was going to say that the best way to think about that is the way it's explicitly defined is any data that is directly or indirectly identifiable, which is why things like MAC addresses or IMEI numbers fall into that category as well. So anything that I can directly link to you or indirectly link to you would be considered personal data as well.
Mm-hmm. Thank you for that. So record keeping, extremely important. Record disposal. Same way as we deal with other data artifacts within the enterprise, within a law firm, within the company, right? You need to be able to dispose the data the right way and in timely manner. Questions to answer. So do you know what personal information you're working with? Again, this we just touched a little bit on how different personal information can be as compared to what general perception is. Do you know where it is kept and how it is managed? Do you know who is responsible for securing and managing the data? And here is the last one, is a good example of interaction between financial department and your IT organization, because usually you will be the ones, you will be consumers of the data, you will be providers of the data, but responsibilities for storing the data, securing the data will be part of your IT organization, or if you have a separate information security organization, they will be bearing responsibility for that. Again, this is a good example of how this should be addressed by organization as a whole, but not on a silo or department by department basis. HR. Traditional justification was that you work for the firm, you work for the company, we have rights to collect as much data about you as we need. So this paradigm changes now. You need to understand that you should not be collecting more data than you actually need, and some data will need to be minimized or flushed from the systems if there is no need to have the data anymore. Transparency, again, keeping the employees informed is extremely important. Another important fact is that when you hire people, right, you usually go through background checks. You also obtain data from different sources. So this also goes into that pool of the privacy data, personal data that you need to deal with. So don't think about it as just the data that was obtained within the law firm. there are different sources of data that are coming in, and you are pretty much aggregating. Accuracy, again, are we keeping data information up to date? Are we making sure that it actually reflects the current, reflects what exact information about the employee? And storage limitation, right? So you need to conduct regular reviews and cleanse the data when it's not needed anymore. So this should become part of your operation. So it shouldn't be a yearly campaigns. It shouldn't be something that you do when you get a reminder. It has to become a part of your standard operating procedures. Real life example. So probably you guys had recently about Under Armour data breach where 150 million MyFitnessPal accounts were compromised. And I'll let Gabriel to comment on this slide because it has a quote from him.
Yeah, for sure. So I think where organizations are still challenges thinking about some of these things in the past, and the statement that Under Armour specifically released was that they claim that no government-issued identifiers were exposed. While that may have been true, the regulation itself specifically does not call out whether or not the citizen data is limited to just, quote, government-issued identifiers. In fact, as written, the regulation specifically calls for any identifiable, again, either directly identifiable or indirectly identifiable data. And had that breach occurred just some days later, let's say we're already past that May 25th date, it is certain that the Office of the Commissioner would be looking at this rather differently. And so we have to get out of that older mentality of thinking that if it's not government issued identifiers, that somehow that doesn't count as citizen identifiable data. That is not the way the regulation is written and or will be enforced.
Thank you, Gabriel. So moving on, latest development. As you know, again, there were certain events associated with Facebook. Facebook is actively dealing with those. There was a blog post by privacy management and general counsel, deputy general counsel of Facebook, which clearly stated that privacy settings and other important tools are too hard to find. So Facebook is reworking their GUI, their feel and look, so that it is easier to find those tools and you can adjust them according to your own needs. Also, one of the requirements of GDPR is to make those responsibility to make companies responsible to tell you in a clear language how the data is collected and used. So again, noted in this post that, as they say, it's also our responsibility to tell you how we collect and use your data in language that is detailed but also easy to understand. That was March 28th. Now, there was an interesting event happening on April 19th. So Facebook has moved more than 1.5 billion users out of reach of European privacy law. So what happened is the records of users who are not residing in EU were moved from international headquarters in Ireland to offices in California. So this move is aimed at reducing exposure of Facebook as a whole of the company to GDPR regulation. There is at the same time some doubt about what this will be able to achieve, because when you talk about data subjects under GDPR and how the companies or firms are held responsible, even if you process, or again, if you're a data controller of the data for privacy data of non-EU data subjects, but you have established EU residents, right, which, as we know, Facebook has, one of the readings of GDPR is that you have to apply the same principles of data protection to all of your data subjects, even those that are not EU data subjects. But again, that's what they did on April 19th. It was published that 1.5 billion users information was moved out of Ireland to US. And the last one was an interesting information from U.S. Department of Homeland Security specifically Secretary of the Department, Christian Nielsen, said that unintended consequences of GDPR can harm the United States' ability to protect itself from the cyber attacks. So there may be some pushback from U.S. government, which may be looking at those regulations and something that limits its ability to fight cyber attacks. At the same time, what needs to be noted is that there are, if you read again GDPR, there are specific provisions that allow data handling in a different way when the matters of the government and the state security are apply. So those are the latest development. And with that, thank you again for attending this webinar, and we are glad to take your questions.
It looks like there are a few in the Q&A. I know some are getting answered through text, but we definitely want to share that information aloud. So I'll just read the one that's still there. And then Gabriel, if you want to just provide the insight that you did, that would be great. So the one that we have says, you mentioned there is no certification for the GDPR. What do certifications from groups like TrustE or Europrise cover, Article 42? And also, are you aware of any codes of conduct being promoted by any legal or financial advisor associations?
I'm happy to take that one if you'd like. So organizations like TrustE and Europrise, what they basically offer are third-party PIAs and similar types of what you can consider gap analysis. So they will basically attest as a neutral party that you are meeting the specific needs of each of the individual articles and provide that as a type of attestation. However, the commission has not stated that they are accepting any of those as actual proof of compliance. I certainly do believe that they would help, because these organizations are largely already trusted to perform these types of assessments, but be prepared to back up any certification that they offer. Again, I would strongly advise that you consult your own internal DPOs and so forth before you purchase any of those types of certifications, because again, this isn't a type of certification the way, for example, PCI DSS offers through actual entities that the PCI DSS organization has blessed as being an auditor or assessor. And as to the second half of that, I am not personally familiar with any codes of conduct being promoted by specific legal or financial advisors. I know Article 40 certainly calls for those things, but I don't know. Andre, I'm not sure if you are familiar with any.
No, unfortunately, I haven't seen anything like that.
And another question, I guess, related to the same one you're answering says, what about Privacy Shield?
That question is a little narrow. So Privacy Shield is being superseded by GDPR for the most part. I mean, Privacy Shield was intended to address cross-border data handling. GDPR, while it has requirements for how it handles cross-border transfers of data, is a bit broader than that. So Privacy Shield would be considered just a small subset of requirements under GDPR, but by and large, those cross-border transfers are going to be covered by GDPR and will supersede Privacy Shield. I think that's your question.
Sure. We had another one that came in saying, what are the penalties for organizations with less than 250 employees?
I'm going to have to default on this one to, again, making sure that you consult with an actual legal professional on this one, but I am not familiar with any restrictions based on the entity size. The penalties are handed down based on revenue and a multiple of revenue, regardless of the size of the actual organization.
Yeah, I agree with that, because there is nothing there that clarifies that if you are smaller than that, it doesn't apply to you, or you will be exempt from paying those penalties.
Indeed. And there were a couple other questions if we wanted to just repeat those aloud. So one question was, is 72 hours to regulator authority or to the individual? So the answer is it has to be reported to the supervisory authority. So not the individuals, but to the supervisory authority, which in this case is usually going to be the EU Commission. Another question was whether or not work email was considered personal data. The short answer is not, unless that email contains citizen identifying information. So just normal communications would not necessarily fall under that category. But if there was something specific within that email that had more identifiable data, then it would be. Generally speaking, email is not considered strictly personally identifiable under most circumstances. For a number of different reasons, and it's been debated through a number of legal circles that you need to be a little bit more information on that. But that is certainly something that we should keep an eye on for how the EU Commission will actually address that. Yet another question was: an employee during their employment records in an online time tracking system, hourly entries on what they do and which client they serve. So to kind of just condense this question, basically what's being asked is, you have some data that is collected as part of your business practices that may need to be shown later as proof in some legal handling or so forth. There are exemptions that are made for data that is necessary to be held as part of either legal or research needs, and Articles 85 through 91 go into explicit detail about what those situations are and what the exemptions may or may not be. And generally speaking, things such as employee data for those specific legal reasons do fall within that category. I would again suggest that you consult your own internal legal and specifically point to Articles 85 through 91. There are both some scientific and historical research exemptions, as well as public access information and things of that nature that do fall somewhat exempt of the right to be forgotten clause, but they do not escape the overall privacy by design clause. So they still need to be protected in the same way. They just may not be completely applicable to the right to be forgotten. I think that covers all of the questions. I don't know if there are any others. I don't see any other new ones that have come in.
It doesn't appear so. So I guess while I let anybody, even though we are at time, if there was any other questions that come in, obviously I want to thank both Gabriel and Andre for their contributions and their expertise on this topic, and again to Red Leg for sponsoring the webinar. We are again recording, and we'll post it within a few days on our site so you can view it, share it. It will be public, so anybody can access it at that point, ILTA or non-ILTA member. And again, if you haven't gotten a chance to complete that evaluation on your screen, please do so before you leave us today. Let's see. It doesn't look like anything else has come in. Their contact information is there on the screen if you do have any questions. If not, feel free to email them to me, and I'd be happy to put you in touch with both of our presenters today. But other than that, thank you guys again, and I hope everybody has a great day.
Thanks a lot.
Thank you.